We're live.
Hey, Sandy, just let me know when we're ready to go. I see we're live streaming, but I'll stand by for you.
We're good.
Okay, we're good. Great. All right. Well, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 23rd, 2021. We have 8 bills on the docket today, and we'll start off with Senator Reedy. But before I do that, I'll just list off the list of bills. So we'll start off with Senator Reedy at 681. We'll then go to 555. Next, it will be 631. 672, Senate Bill 700, 617, 702, and then 712. So with that, we'll start off with Senate Bill 681. Senator Reedy, good to see you. Welcome back. We miss you. And I'm sure you miss us as well. So all right.
I do sometimes. No, I'm happy to be back to present this legislation. I do miss the camaraderie. And hopefully we'll all be able to be more camaraderie oriented in future sessions. So with that introduction, I'm honored to be here before you, Chairman Smith, to represent and members of the committee, Senate Bill 681. And it was an issue that was brought to me by the Maryland Vehicle Title Association. And I think it's a very common sense little change to the law. It would exempt a vehicle from Maryland safety inspection if and only if ownership is transferred from a person's business that they are either fully or part owner of to them individually. It's a very similar exemption. It's basically the same exemption as when you were leasing a vehicle, and then you can have the option to keep the vehicle after you're done with your lease. This is just a little change in Maryland law. I think the other exemptions to safety inspections have to do with historic vehicles. So the vehicle is not changing hands. It's simply going from a person's business to themselves individually. I am aware that we have a little bit of opposition in the file, and we are working. Our advocates and I are working to see if we can smooth out any issues and see if we can come to some agreement. But I think it's just like a common sense thing for ease of business. We have a lot of people who may buy a vehicle for their business and just want to be able to, if they decide to dissolve their business or they decide to do something else, that they can just transfer that ownership to themselves personally without going through the whole safety inspection. So with me today is Lisa Thompson from Maryland Vehicle Titling Association, and I'd be happy to turn it over to her, but of course happy to answer any questions if that's if we want to do questions.
Excellent. So Joe, we'll hold off on questions until after your panelists. So
that's right.
Ms. Thompson, you are up next. Good to see you and welcome.
Thank you. Good afternoon, everyone. My name is Lisa Thompson. I'm a partner of Maryland Speedy Tag and Title and also vice chair for the Maryland Vehicle Title Association. I've been in the industry for over 10 years, and as a representative of the Titling Association, we represent over 100 tag and title agencies. We are a third-party entity of the Motor Vehicle Administration. Our purpose is to facilitate the exchange of ideals among its members, encourage sound business policies, provide industry education to its members, and foster constructive, progressive motor vehicle title agent legislation. Also discourage destructive, retrogressive motor vehicle title agent legislation, and to promote confidence, respect, and good fellowship in the motor vehicle title industry. And as a representative of the association, we strongly favor Senate Bill 681. We have spoken with the NVA and the state police, and they have taken no position. The state police is the actual entity that oversees the safety inspection program. This bill will prevent business owners, who are mainly small business owners, from incurring additional expenses unnecessarily. Currently, the state of Maryland also allows transferring a vehicle from a sole proprietor to their individual name. It's processed the same as a gifting transaction, and it allows the state of Maryland to exempt from safety inspections. It's also, as the senator mentioned, it's allowed for gifting amongst immediate family members, and they do not require safety inspection, and as well as leasing vehicles. So as business owners who have incorporated under a different structure but has the same type of ownership should be reserved the same type of right and opportunity. As a title agent, we have witnessed many business owners that come into our office, as mentioned, that's going to dissolve their business. And often that is faced with a lot of hardship. So they are disheartened when they learn that they have to re-inspect the vehicle that they presently had already owned. And this oftentimes causes a delay in the process of transferring the vehicle properly. So the state has already established exceptions for safety inspections, and business owners that have company vehicles transferred in their names should also be included, especially since this impacts many of the small businesses who has been dealing with a lot of challenges and hardships during these difficult times. So I thank you for your time.
Excellent. Thank you, Ms. Thompson. And thank you, Senator Reedy. Looking around the room for questions from the committee. Senator West has one.
Thank you, Mr. Chair. Actually, I do have one. So right now, a business that has a vehicle, doesn't it have to have it inspected periodically?
No.
No. So it buys,
Okay, thank you.
it buys the vehicle and the vehicle never gets inspected again?
Can I answer? So the vehicle only gets inspected once it transfers ownership.
So if a business owns a vehicle for 20 years, it's never inspected, is what you're saying?
Initially, it is, as other transactions.
And when we're talking about inspection, we're not talking about what you and I do with our personal cars, have to go in and have the exhaust system checked, right? It's a more significant inspection than that?
It's the safety inspection.
So what, checks brakes and all that sort of thing?
Correct.
Okay, great, thank you.
You're welcome.
Okay, excellent. Seeing no further questions, that'll conclude the hearing, the testimony in the hearing for Senate Bill 681.
Thank you, Mr. Chairman.
Senator Reedy, thank you very much, and always good to see you. You're always welcome back here at JPR. I know you miss us, and we miss you.
I do.
All right, excellent. All right, now we have another JPR alum or a refugee, whichever way you want to, however you want to characterize it. Senator Young, we've got Senate Bill 555. You're up next.
All right, thank you. Can you hear me? Very good. Well, it's good to see the few of you that are there. I'm sorry that things are not going well. I have Senate Bill 555, which is a sexual assault survivors. It improves the process that many survivors of sexual assault face when they're informed that prosecutors are declining to charge their attackers. According to the Rape, Abuse, and Incest National Network, 995 of every 1,000 sexual assault perpetrators will never face prison. And the majority of the cases will not be reported, and most of the cases that are reported don't lead to arrest or even an attempted prosecution. Women of color are disproportionately affected by sexual assault, and they're more likely to not report their attackers. But there's a lot of factors that contribute to sexual assaults not being reported. But the trauma of survivors having to relive their attacks and face police and prosecutors questioning is regularly cited as a major point. The legislation here simply ensures that survivors have a victim's advocate during questioning, and that empower survivors to hold meetings with the prosecutors. There are some amendments. What the bill simply does, it says that if someone reports a case and the state's attorney dismisses it, that the victim has a right to talk to the prosecutor, assistant prosecutor, to find out why the decision was made. Again, it's very frustrating to someone when they are assaulted. They make a charge, they come forward, it's dismissed, and they have no satisfaction of even knowing why. So under the amendment, all it requires that the assistant state's attorney would explain why they're not filing a charge or why they're dismissing the charges. The meeting required under this section can be conducted in person, by phone, or by any other means mutually agreed upon. So, you know, all in one sentence, it just says the person filing the charge and it's dismissed, they at least get an explanation as why, so that they at least have that satisfaction, if not the satisfaction of seeing it brought to justice.
Excellent. Thank you, Senator Young. And so now we'll switch over to your primary witness, your only witness here today, Miss Ashley Young.
No relation.
No relation, maybe, I don't know.
At least I don't know.
Yeah, Miss Young, you're up next.
Yeah, I don't know either, but
It
it's
could
a
be.
good last name. Yep.
Yes.
So thank you so much to the chairman and members of the committee. Thank you, Senator Young. My name is Ashley Young. I'm the managing attorney at the Maryland Coalition Against Sexual Assault in the Sexual Assault Legal Institute. I'm here on the invitation of our executive director, Lisa Jordan, to support a favorable report on Senate Bill 555 with the sponsored amendments. At the Sexual Assault Legal Institute, we help victims of sexual assault throughout Maryland to address their myriad of legal needs. Our attorneys provide services to over 400 survivors every year, many who reach out because they've made a criminal report about their sexual assault and they haven't heard anything from anyone since. This is common sense legislation. It provides for basic human decency for survivors and recognizes that it's traumatic just to go to the police department and make a report at all. And so not hearing anything is really just driving home that trauma with no resolution. Survivors deserve to know if their case is being dismissed or if their prosecutors are not moving forward with a charging document. And in my experience, when prosecutors do meet with survivors to provide an explanation, while they may be disappointed, while they may be sad or distraught, it does give them some modicum of closure, and at least they feel respected. So for these reasons, we urge a favorable report on Senate Bill 555. Thank you.
Excellent. Thank you, Ms. Young. And with that, that'll conclude the testimony for Senate Bill 555. And I'll turn to the committee for questions. All right. Seeing no questions. Senator Young, yes.
Mr. Chairman?
Yes.
Yeah, if I could, I just wanted to say that the amendment was negotiated between the Maryland Coalition Against Sexual Assault and an assistant state's attorney. So it was worked out between someone from each side, and it's the amendment we came up with.
Excellent. Well, thank you for that. That'll be helpful during our voting discussions. Okay, well, excellent. Senator Young and Ms. Young, thank you both. Have a great afternoon.
Thank you.
All right. And with that, that'll conclude the hearing for Senate Bill 555. We'll now move on to Senator Kagan. Senator Kagan here.
She's not here yet, but her staff said that she was logging on a couple minutes ago. So if you want to start with her witnesses, or if you want to go to Senator Waldstreicher, I'll try to get his witnesses in the hearing room.
Okay, let's do this. We'll start with Senator Kagan's witnesses first, just because I don't want to spring on Vice Chair Waldstreicher to give him
Yep.
a moment. So let's just start off with the witnesses for Senator Kagan. the primary witness for Senator Kagan is Mr. Roberts. So, Mr. Roberts, if you would like, you've got 5 minutes. The floor is yours, and we'll turn it over to you for Senate Bill 631.
All right, thank you very much. Good afternoon, I'm Brian Roberts, and I'm the Director of Montgomery County's MC 311 Customer Service Operation. I think State 1311 is a good idea as it makes government more accessible to citizens. So what's 311? Well, 311 provides a single contact number and website for non-emergency requests for government information services and complaints. There are 4 types of requests to 311 that are handled by our extensive knowledge base of information provided by experts in each county department. So first are general information requests, and then there were 3 types of requests requiring fulfillment: requests for county services, referrals to county experts, and then complaints, compliments, and comments. And we're open 7 a.m. to 7 p.m. Monday through Friday, and mc31.com is available 24/7. Roughly 70% of our calls since the pandemic and the resulting economic stress involve social services, trash and recycling, and permitting services. Pre-COVID, mass transit was number 1, believe it or not. We handle up to 45,000 calls per month, and sorry, got another call coming in. I thought I had that turned off. We have about up to 45,000 calls a month with 40 budgeted positions for customer service representatives and another 11 staff members. Usually 30 to 32 people are on the phone at any given time. And during the COVID-19 emergency, we've also used temporary service contractors and reassigned employees to manage high volume call periods. We've got a bunch of key performance metrics to make sure we provide excellent customer service. And we do a lot of measurements. We try to minimize abandoned calls, answer calls quickly, handle calls within 4 minutes on average. And we place a strong emphasis on accuracy. During the COVID period, the abandon rate was very high, but we've been able to bring it down with a number of measures. We support emergency response during major storms and public health events, and sometimes we extend our hours occasionally to 24/7, and all call handling employees are considered essential. And then with all this information, we track every call and every website visit. So we provide management with a lot of information about what residents need and want, and have input into the budget process. So a lot more detail is in the written testimony. That's what I've got for you.
Excellent, thank you. And I see we have Senator Kagan is here. So Senator Kagan, welcome to the Judicial Proceedings Committee. You just heard from Mr. Roberts, so you're up next. Good to see you.
Thank you, Mr. Chairman. Very glad to be here. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. And as I think this committee probably knows, very proud to be the chair of the statewide Next Generation 911 Commission for the last 3 years. This year, there are 5 911 bills, and I know we're not supposed to love our bills too much, but this is kind of my favorite bill this year, and I'm really excited to tell you about it. And I'm sorry that I got here before Brian Roberts got to speak, but I just want to tell you what this bill does and why it's such a thrill. So there are currently 6 jurisdictions that have 311 centers. The demand on them, as I'm sure, and unfortunately I didn't get to hear Brian's testimony, but I've read it and it's really compelling. I encourage you to take a look at it. The reality is that especially during COVID, but at all times, people call 911. Where can I get a COVID test? Where can I get a vaccine? When does my recycling get picked up? A tree just fell on my car. Important, but not urgent calls. And the problem is that our 911 centers are overloaded. It's really hard, as Senator Jackson and Senator Riley know, who have been my partners in this for the last 3 years. It's really hard to recruit, train, and retain 911 specialists. It's high stress, high demand, and over 5 million calls to 911 come in each year. The reality is that a bunch of the calls that come into 911 centers aren't emergencies and could be handled by other folks without the totally top-notch training and top-notch experience and ability to handle stress. We've got the need also based on the lack of broadband. People who may have a power outage may not be able to look something up on their computer or may not be able to afford Wi-Fi at home. So the demand and the audience for people who have needs to interact with government, to get customer service, to get information is high and growing. On the governor's website, 211 is even linked. It has a 211, a 311, a 911, and 311 looks like it's statewide, but as I indicated, only 6 jurisdictions currently have it. I have been working, and the commission has been very lucky to work with Russell Strickland, the head of MEMA, the Maryland Emergency Management Agency. I'm thrilled to have him here with permission as one of the witnesses to be able to share his insights on this. We also have Janice Quintana, who is a national expert on 311 and ran the DC 311. So why is 311 so great, in addition to what I've already said about lightening the load in our 911 centers and providing resources for those who don't have Wi-Fi access to look up some of this material, some of this information themselves? Because it's so hard to attract talented people to our 911 center, 311, another asset, is their ability to hire someone and give them some experience under the headset, but they're not quite ready to handle the pressures of 911. Let's ease them in slowly through a 311 center. What about someone who's having, behavioral health challenges, depression, anxiety, suicidal ideation, or is just burnt out and needs a break from 911? Maybe they're getting ready to retire. 311 could be a place they shift to from a 911 center as a way of mentoring, training, and still providing expert public service to the community. So this bill, colleagues, was crafted to create a statewide 311 center so that everybody anywhere could have access to their government for free and without needing access to the internet. There were a number of small issues, and we were a little too optimistic. There were a number of issues like, what about the 6 jurisdictions that already have 311? Would they be subsumed within this, or could they have the option to continue their own? What about the training? Where would it be housed? How would this all work? So there are just a few issues. So rather than believing that we were totally ready to launch this, Director Strickland very generously agreed to help the 911 Commission work with a talented bunch of the key stakeholders to figure out how this could work, figure out the details, get a better idea of the cost and the benefits. And then we can come back in 2022, both through the 911 Commission with their buy-in again, and then coming back to the General Assembly to get the buy-in and to create this commission, this work group, which I envision is really only going to be 2 or 3 meetings. We really do need the official legislative blessing to get the right people in the room. We've had the right people in the room in the 911 Commission, and that's why we've been so successful. We've had 911 directors, telecommunications folks, cybersecurity people, access for people with disabilities, a 911 specialist, many other experts, and it's made a huge difference. And every single one of them has pulled their weight and offered value added. In this work group, again, we need the right people in the room. And many of those folks are similar to the 911 Commission, but we need it off premises. It should be chaired by and convened by MEMA. And again, Director Strickland has expressed his willingness to do this. So for better customer service, for access to government, in important but not emergency items for an ability to help some of the lower income jurisdictions that aren't able to invest in creating a 311 center, and to provide access to really important information like COVID testing and vaccines. I am very excited about the idea of launching a statewide 311 program. And I'm sorry that I missed Mr. Roberts' testimony, but I know he's such an expert. And so with that, Mr. Chairman, colleagues, I want to pass it off first to Director Strickland and then to Janice Quintana. And I would be thrilled to take any other questions. Thank you for your attention to this really exciting opportunity.
Excellent. Thank you, Senator Kagan. And so we'll move on next to Mr. Strickland. Strickland, you're up.
Thank you very much, and thank you to the entire Judicial Proceedings Committee for allowing me the opportunity this afternoon to speak on behalf of Senator Kagan's bill. She does have the passion, and I think that is so extremely important. I am the Executive Director of the Maryland Emergency Management Agency, and I am here again to testify on this bill, which would establish a statewide non-emergency telephone system. And I offer this in my testimony to you, not just in my capacity as the current executive director of MEMA, but also based on experience as a local emergency services director who was responsible for a 911 center, but also someone who began their career as a 17-year-old police dispatcher clerk and one of the first 911 call takers in the state with the original old PBX board where we stuck the line in the for the phone. This bill, and this is the piece that I'm really passionate about, would allow the state to provide assistance to local public service answering points. You know, I truly believe state government is here to assist and work with and partner with and help local jurisdictions. And this is in an area where local jurisdictions are overburdened. In many Maryland counties and municipalities, a large percentage of calls to the 911 centers are not the type of emergencies that require immediate dispatch of fire departments, law enforcement, or emergency medical technicians. Rather, many of these calls are far less urgent matters, like a car blocking someone's driveway, broken traffic signals, a tree removal, whatever it might be. And where these 311 systems have been implemented, like particularly Baltimore City, Baltimore County, Prince George's, and Montgomery counties, the volume of calls to the 911 centers, particularly as you just heard from Brian Roberts, it has been tremendous to the 311 service and has greatly eased those calls onto the 911 centers. The establishment of this 311 call center is beyond easing just the burden on local 911 centers. It would also allow an opportunity for local jurisdictions for training and building experience for their newer dispatchers before they're thrust into the high stress world of 911 call centers. It could serve as a training ground for early career professionals in this regard. And additionally, the 911 call takers every now and then need a break. And this would be a perfect landing spot for them to take some time and to kind of recoup, manage their stress a little bit, and then be able to come back into the 911 environment. So it's really also a major benefit for the current 911 folks. MEMA could be situated to assist with this concept without any problem. We already run a statewide watch center, which could be easily expanded to handle 311 call load. Having worked through a wide variety of state emergencies, the agency has experience and the physical infrastructure to assume the duties of a 24/7 call center. We're not a single discipline oriented agency. You know, we serve all. And MEMA staff, like dispatchers, must be adept and flexible in responding to a vast array of potential constituent issues. MEMA has shown the ability to efficiently stand up new call centers. While many states took over 6 months to establish a school violence hotline, we did it in 6 weeks. So the proposed amendment to this bill that Senator Kagan was speaking about would delay it for this year, but would give us the opportunity to do a good review and be able to come back with some solid information as to establishing the exact need, the concept of operations, which is going to be important. One size doesn't fit all for every jurisdiction in the state, the necessary budget, identify any potential future legislation that might be necessary, and then a source of revenue or funding that we might be able to identify. MEMA can manage this review. The amendment would ensure that when the center is up and running, it would be well functioning and financially stable and meeting the needs of the local jurisdiction. So with that, I really thank the committee the opportunity this afternoon to speak, and again to Senator Kagan for her fortitude for bringing these kind of things forward. But again, I think this is definitely one way the state can support the local jurisdictions, and it will definitely assist the 911 system in Maryland. Thank you.
Excellent. Thank you, Director Strickland. And now we move on to Senator Kagan's final guest, Ms. Quintana. And then Senator Jackson will get you, I see you have a question. We'll get you right after the presentation.
Okay, I've been muted. Can you guys hear me?
You can.
Great. I'm glad to be here. I'm honored to be here. I am a 3-1 pioneer, a government nerd. I've been in this business for a very long time. I originally worked in private industry and customer service, and I was recruited to come to Washington, D.C. to run Mayor Williams' Mayor's Call Center back in 2002. And then I was appointed by Mayor Fenty to be the director of the Office of Unified Communications, which made me the director of 911. And then we implemented 311. And then I was later recruited to help Charlotte, North Carolina with their 311 center, and later recruited by Atlanta, Georgia to run the Atlanta 311 center. So I've been on the front.
Eunice, your video isn't on if you're able to flip that on.
Okay, sorry.
You were on earlier. Sorry, Mr. Chairman.
There you go, sorry. So I've really in love with 311. I've seen the work that it's done to help improve cities. It really was a game changer in breaking down silos and improving government services and city services, and improving engagement and access to local government by anybody in any demographic. They've grown quite a bit. They used to just be a call center, brick and mortar, but now they are technology hubs. They use all kinds of technology, from mobile apps to artificial intelligence to texting to online services. So they've really grown over the last 20 years. And one of the main reasons when they were first created was to take the burden off the 911. So if you think right now, when there's a winter storm and there's down trees or power poles that are out or big potholes, people would call 911, and it became a very big burden. So even in DC, we had a 311 that fell under the police department, and we took it off of them and made it just a 311 center. So you think about how much pressure it takes off of 911. I was just ironically on a call earlier with the 911 Institute, where the directors of 911 from Alexandria, Virginia and New Orleans were on there, and they were speaking about how much 311 helped them during this pandemic. And also a 911 center in Colorado, when they had all these big fires, they were able to use their 311s, and that's the same thing that's happened in California. So we know all the big storms that have happened in Texas. All those 311 centers from Houston, Dallas, San Antonio, and Austin were overwhelmed, but they were able to get back on and start taking a lot of the calls during the snow for water delivery or food delivery or power outages. And right now, during the pandemic, a lot of these 311s have become the hotline. They have been the place to get information, to schedule COVID testing. Now they're scheduling vaccination. Some of these centers are scheduling food delivery. Anyways, I think it's great to have a 311, and it's great that it should be in Maryland, because the first 311 in North America was created in Baltimore 20 years ago. Thank you.
Excellent. Thank you very much. It was very informative. Thank you. And thank you for your dedication over the years to this issue.
Yeah, thanks.
Cool stuff. All right. So we'll go to Senator Jackson first, and then we'll go to Senator West.
Thank you, Mr. Chairman. And just wanted to chime in with my partner for the last 4 years on the next generation 911. I certainly support this wholeheartedly. My home county, Prince George's, is one of the counties that has the 311 center, and it's a terrific outlet for citizens. I even find myself calling them, even though I'm a county employee and I'm an elected official, but it certainly works. And for members, if you want to get a real inside look or informational, if you have some information you're seeking, Delegate Derek Davis, the chair of Economic Matters, his agency that he works for in the county, Community Relations oversees 311. So it's a dynamic program, and I look forward to supporting this bill and hope that the members do as well. So thank you.
Excellent. Thank you, Senator Jackson. And so we'll move on to Senator West and then Senator Lee.
Mr. Chair, and thank you, Senator Kagan, for bringing this bill to us. It sounds like a simply fantastic program. I've got some questions about the implementation, though. So we've got 6 jurisdictions that have it right now. I write down Baltimore County, Baltimore City, Montgomery County, Prince George's. What are the other 2?
The other, let's see, one of them is unexpected. It's St. Mary's. Here we go. Anne Arundel, Baltimore City, Baltimore County, Montgomery, Prince George's, and St. Mary's.
What have I missed?
Anne Arundel and St. Mary.
There we go. Okay. Anne Arundel County. So right now, apparently there are 6 different call centers in those 6 different counties.
Mm-hmm.
As I read the bill, it's requiring 2 call centers, one to cover the more urban counties and one to cover the more rural counties. So would that mean that we would close 4 of the existing call centers and then consolidate everything into 2 call centers, one for the urban counties and one for the rural counties?
Thank you so much for that question, Senator West. So first off, the idea of 2 call centers would basically be a primary and a backup in the same way that our 24 911 centers have a primary and a backup. God forbid if there's COVID or a flood or something in one of them, that we would still have another location. And I thought they should be spread far apart. The question of what to do with the current 6 is one of the issues that I think we would need to deal with in these 2 or 3 meetings that we would do over the interim under the direction of MEMA. There may be, Prince George's County might say, we're fine with the way we're doing it. We don't need to be a part of it. People can transfer 311 calls if they come into the statewide center, but we're fine with paying for it. Maybe Dorchester County says, we can't afford it. We love the idea, but we can't afford it. So sure, we'd like to be in on it. The idea is making sure that information is available and accessible. And something I didn't mention before, and I don't know whether Brian referenced it or not in his testimony, but languages. If you think of 24 different jurisdictions, hypothetically setting up a 311 center, think of all the language line costs. Think of needing to have people at least with Spanish language skills, again, with hiring at one center or even one center at MEMA and maybe a backup center or something, if that's even needed. Language capacity and fluency would be one of the much more efficient ways of handling it. So fundamentally, Senator West, the question of what the 6 jurisdictions would choose and whether they would be delighted to be part of a statewide or whether they would want to opt out, and then we would just cover 18 or 20 of the jurisdictions. It's all good. But fundamentally, we need to have 311 access for anyone living, working, or traveling through Maryland for non-emergency use.
Well, if we pass this bill, would this transfer all authority to resolve all these issues to this, what is it, task force?
So the work group, the idea is that we, among the people that we have included are representatives of 2 counties that do have 311 centers right now and 2 counties that do not have 311. And so we want to get both of their perspective. And obviously, we'd be happy to hear testimony or collaborate with anyone. So this is the minimum, but if anyone else wanted to join in, that'd be fine. But there are,
I'm sorry. Go ahead.
No, just one more thing. There are both fiscal and technological issues that we would need to figure out before we could launch such a program. Go ahead, Sarah.
I guess my question is, should we aspire to a single statewide 311, or would it make more sense to have more localized, smaller operations? I would guess that the Baltimore County operators right now are pretty good at pointing people to the specific parts of Baltimore County government that would solve their problems. they would need a lot of training to point people to Garrett County's sections or Somerset County's sections.
So one of the challenges is we wouldn't want to do an unfunded mandate and say, okay, all 24 jurisdictions, thou shalt have a 311 center, because some really don't have the fiscal capacity or understand that there really is a need. The question—
I can understand that maybe we want a statewide program, but instead of having one center in, say, Linthicum with
Right.
500 employees, you might want to have satellite centers in various parts. And so, for example, we have several area codes. So if I'm in the 410 area code, it would be probably dysfunctional to have the call center in the 301 and have a 301 person trying to talk to 401 calls.
So if you have a 410 area code, but you're visiting me in Rockville, you dial 911, it doesn't matter what the area code is on your phone. You're going to get the local 911 center, and you will end up talking to my folks who happen to be in Gaithersburg.
But are the Rockville people going to know what people to access in Cecil County?
So some of that is training, some of that is internet access, and maybe I can toss that to Brian Roberts to maybe give a real life example. Brian, if you're able to unmute again, as to how you would deal with stuff. But in the meantime, one of the things in his testimony that I thought was so effective was the idea of Montgomery County's 311 replacing 13,000 phone numbers and 10,000 email addresses. So if I were visiting you and in Baltimore County, I wouldn't know the right place to start reaching out to folks.
Believe me, I see the wisdom of this. There's no
yeah.
On the other hand, it's going to be expensive because instead of people like me looking online and trying to find telephone numbers, I'll just call 311.
100%.
Hopefully get a responsive answer.
Exactly.
So instead of spending my time on the internet, I'm going to use personnel on the other end of the phone, and they're going to need to be a lot of personnel to answer all these questions.
Brian, can you answer more?
Yeah, Senator West, the way this is handled is we have a group of people, a small group of people, it's actually 3 people, who work with all the departments to figure out exactly how each question should be answered. They, figure out the question and the answer, and we put it in a database. And we've built this knowledge over a period of 10 years. But when we started, it took about a year to build it. But you build it as you go. But that's how it works. You have some people who have the knowledge and the relationships in the departments. So in this case, those experts would have to go beyond, the county level. They go beyond the county line, but that's how you do it. Does that make sense?
This is a fascinating project. It's great. We just need to work out the logistics. Thanks.
Well, Senator West, if you'd like to be the other legislator, because I know I'm all in. But I think we have 2 delegates and 2 senators, but we can talk about that. Yes, we do.
We'll talk. Thank you.
Okay.
That's how it works. All right. We will go to Senator Lee and then Senator Hettleman.
Thank you, Senator Kagan. I think this is an absolutely wonderful bill. I think it's much needed now, especially with COVID-19 and pandemic still ongoing, because not every call rises to the level of a 911. And I think, particularly with underserved communities, I think, and communities of color, they would be vastly served by this, and especially our immigrant community. But I think Senator West asked you some of the questions that I was going to, but I have some additionals. This looks like, and maybe Brian can answer this, I guess you would be able to provide BEMA would be able to provide the kind of the state guidance and expertise where maybe the localities who don't have that money or resources to be able to develop their own plan. I guess you would be able to extend that to them since we're state. And also, do you have, I guess, the resources to carry this out as you envision in the legislation, or are we still in a work in progress with respect to funding? And I trust that the governor is strongly behind this.
Thank you for the great question, Senator Lee. So how each of the local jurisdictions might want their callers or their residents dealt with, I think we would have to collaborate and learn. Let's say Garrett County says, we don't want you doing anything, Garrett County, just transfer any 311 calls to the county manager's office or something. they may change their tune once they realize how many calls they're going to get. In terms of funding, this bill as amended would be a work group, and Director Strickland said that he can help manage that and supervise it or convene it using existing staff and resources. And certainly my 911 connections and relationships and ideas can certainly be a helpful backup. And so I think we can get it done. We're talking about 2 or 3 meetings. This isn't going to be some monster thing with a fancy, bound 69-page report. I think it's going to be a brief report with lessons learned. The last question you asked was about the governor. First off, I'm not the spokesperson for the governor's office, but I would venture to say that Director Strickland would not have gotten permission to be with us today if they hadn't signed off on this idea. And I did go to the governor's office very early in this conversation last fall, and because I've been pretty jazzed about this, and I think it's a cool, think outside the box way of providing customer service.
I think it's a great investment. I think and this is very visionary too, because you're thinking ahead, you're being proactive. And I've worked with Russ. Russ, thank you. Thank you for all your work, especially on cybersecurity. We have a lot of great talent and leaders working for us. And I'm so glad you're there because you're protecting us in many different ways. So
Yes, yes.
Thank you, Senator Kagan, for this wonderful piece. I'd love to work with you on this. Just keep us up to date, okay?
Thank you. Director Strickland, I don't know if you can speak to the question of the governor's position or if what I said is okay. I assume your presence here speaks volumes.
I think what you said is okay. That's probably the best.
Perfect. Thank you.
Excellent. Thank you, Senator Lee. So we've got Senator Hedelman and then Senator Castley.
Thank you very much, Mr. Chairman. I echo my colleagues' praise for the bill. You are immersed in so many of these 911 and 311 issues, and it occurred, and I am not. And as we were having the hearing, I looked up 211, and because I know that is another service resource out there, and I realized that it is run by a nonprofit. And if you could just talk a little bit about is there no more need for 211? If this bill were to go into effect, is there a differentiation? Was that the reason that it was created, to fill a void? Can you just speak to that, please?
Sure. Thank you, Senator Hedelman. There are a lot of other 3-digit numbers. As you all may know, 988, which is a suicide prevention hotline, is going to be rolling out in July of 22. And if you're a T-Mobile subscriber, I just got to do the public service thing. If you're a T-Mobile subscriber only, that is active right now, but others 988. I don't see 311 as necessarily superseding or replacing any other 3-digit numbers. First off, it's not my place to say. And second off, I don't think we have the data. So there's 211, there's 511, and 911 is always sacred. So I think the work group could have the conversation and explore that. I don't envision it replacing or supplanting any other number. That was not part of my thinking.
Okay, thank you.
Thanks.
Thank you, Senator Hedelman. We'll go on to Senator Castley. You're up.
Thank you, Mr. Chairman. Can you just see, I'm trying if I have the basic concept right here, because on 911, we have a centralized system that then automatically goes to the local for the help. You were saying I'm from Hartford, I'm traveling through Montgomery County, I call 911. Doesn't go back to Hartford, it goes to Rockville, and the 911 center in Rockville sends somebody to help me in Montgomery County or wherever I am.
Yep.
And so the information, the experts, the people with knowledge are the people in Rockville, not centralized in somewhere. But it sounds like the 311 is sort of a major shift, because while it's a centralized number, instead of sending me out to the locals, this centralized people are actually going to try to solve my problem, which would be a big shift from where we are with 911. Am I understanding that correctly into the structure you're looking at?
Thank you, Senator Castley, and I'm happy to have any of my witnesses chime in. Janice, maybe you can help with this too, but let me just use your example, Senator Castley. You're from Harford County, you're traveling through Montgomery County, we'd love to have you anytime, and you call 311. And let's say that your question is about what day is your recycling coming this week? The person answering the phone could easily look that up for you. You're in your car or you're waiting in a restaurant. They can look that up and provide that information for you. So it's not because they're based in Rockville or Timonium or La Plata. It's a question of them having access to data. So Brian Roberts talked about having a database. There's also access to the internet and being able to do a quick search on Harford County, look in your neighborhood, get that information, or transfer you to a local Department of Trash and Recycling person who could answer the question. Brian, am I close? Or Janice? Yeah, is there anything you would add? Okay. I got a thumbs up from Brian. Okay. Thank you, Senator Castley.
So thank you, Senator Castley. We'll go on to Senator Bailey.
Thank you, Senator. I had a couple quick questions. I just wanted to know locally in St. Mary's, we currently have one of these.
Yes.
311 systems. How would this affect what we're doing in St. Mary's County currently?
Thank you, Senator Bailey. So there are 6 jurisdictions, as I've said, and St. Mary's is among those, which is fabulous because a lot of the rural counties have not chosen to set these up yet. So part of the reason for the work group is to check in with St. Mary's County and say, do you want to keep paying for it and having your own that is located in St. Mary's County, or do you want to be part of a statewide system and then have it funded at a statewide level? I think that's one of the key parts of the conversation, actually.
I appreciate that, and I appreciate the work you've done on this. I know for us in 911, it is extremely challenging with the Chesapeake Bay and the Potomac River, because there's no doubt, even for our citizens that are on land, if they're near the water and they dial 911, they end up talking to Virginia and many different counties. They end up over in, on the Eastern Shore, talking to counties over there. So it is a struggle it all determines which way the wind's blowing and how your signal's picked up by a tower is where you might end up discussing it. And that being said, does Virginia have a 311 system that would work in compatibility with this?
So let me start, and then Janice, if you could unmute and come back on video to help us with that. But Senator Bailey, if Janice is still around, Senator Bailey, you were just talking about what Senator Jackson knows very well is GIS, the Geographic Information Systems. And that is one of the key parts of next generation 911 to make sure that we can get more precise in finding you to send a police, fire, or paramedic in case of a 911 emergency. So that's where you want it to be accurate. You want it to be local and not just based on a cell tower, and it might not even be the right cell tower or in the right state, let alone the right county. For 311, the advantage of having it statewide is that it doesn't matter. So if you're calling 311 and you're in St. Mary's or you're in Calvert or you're in Charles County, each time it would be picked up at the same statewide center, and they could provide you with the support and information that you need for whatever your location. Janice, do you want to help me on Virginia knowledge?
Yeah, Virginia has a few 311s. They have Alexandria, Virginia, and much further down, Virginia Beach, Norfolk, Hampton. A lot of cities do have the 311s. Fairfax County does not right now, or Arlington, but other cities do. And the DMV area, that little area is very tricky because everything is so close, depending where you are, even with 311. But for the statewide, you're right. You could go to the same center and they could get you to another city if need be.
Yep. So one of the key aspects of this work group and some of the key components, Senator Bailey, would also be the telecommunications people to make sure that figuring out how, again, going back to Senator Castley's question, he has a question about Harford County, but he's in Montgomery County. and making sure that that the wire lines are gonna all be processed easily and that the information can get back for him.
Thank you.
Yeah, and I would just add, it doesn't always have to be a telephony call. There's all kinds of other technology that would help with that, AI and chatbot and online and mobile apps.
AI, artificial intelligence.
Intelligence, yes.
Okay. So, Mr. Chairman, I don't know if there are other questions, but this has been really such a pleasure, and I'm glad that many of you share my excitement about this issue.
Clearly a lot of excitement in the committee. Well, thank you very much, Senator Kagan, and thank you to your panel. Have a great evening. And with that, that will conclude the hearing for Senate Bill 631. Senator Kagan, have a great afternoon. Thank you.
Thanks, you too, Mr. Chairman. Bye-bye.
Excellent. Great. See you later. All right, next we will have Senate Bill 672 with Vice Chair Waldstreicher. Senator, you're up.
Thank you, Mr. Chairman. Before us now is Senate Bill 672. As many of you know, drunk drivers are responsible for 1/3 of all Maryland's traffic fatalities. So on average, there are 7,200 impaired driving crashes each year, and that results in 3,500 injuries and 160 traffic fatalities. Those are our friends and neighbors and constituents. Half a decade ago in 2016, we made a strong first step. The Drunk Driving Reduction Act, which we also know as Noah's Law, makes Maryland's roadways safer by mandating ignition interlock for drunk drivers upon conviction and requiring strict adherence to the ignition interlock program in Maryland. In Maryland, as many of you know, the majority of drunk drivers end up with probation before judgment after their first arrest. Upon second arrest, drunk drivers are convicted of a drunk driving offense. Noah's Law has required that second-time offenders participate in the state's ignition interlock program. This legislation will simply update our law based on what we've learned over the past half decade. We must close the gap between probation before judgment and conviction by requiring all drunk drivers to complete 180 days on an interlock as a condition of their probation. So let's start with this. Is there truly a problem? The answer is yes. In 2019, there were about 3,000 PBJs for 21-902 violations. That's driving under the influence of alcohol. There were 36 PBJs for violation of 21-902B. That's driving while impaired by alcohol. And that number is consistent from year to year, meaning about 6,000 or 7,000 Marylanders will go on to reoffend, finally get convicted, and then be put back on an interlock. According to the MVA's 2020 report, impaired driving crashes have increased by approximately 9% since 2015 and have remained relatively steady over the past 2 years. So here's what we know. Ignition interlocks prevent recidivism. Research has repeatedly found that drivers who have interlocks installed are up to 75% less likely to have repeat drunk driving offenses than drunk drivers who do not have an interlock device installed. Here's what we also know. The earlier an ignition interlock device is put on, the greater the impact in reducing recidivism. So the 2016 study in California found that ignition interlocks are 74% more effective in reducing DUI recidivism than license suspension alone for first offenders during the first 180 days after conviction. The study also found that interlocks are 45% more effective in preventing a repeat DUI incidents when compared to license suspensions alone during the second 180 days after conviction. Ignition interlocks are 70% more effective than license suspension alone in preventing repeat offenses for second-time offenders compared to license suspension alone for the first year of use. So ignition interlocks prevent drunk driving. Here's another way we know that. In 2020, just last year, Maryland's ignition interlock program, meaning the current law, prevented more than 3,800 attempts to start or operate a vehicle where the driver's blood alcohol concentration was greater than the legal limit in Maryland. Let me say that again because we've been saying a lot of statistics. I've been saying a lot of statistics on here. 3,800 people with ignition interlocks already on their car attempted to start a vehicle when they were drunk, and the ignition interlock stopped them from doing that. That's an incredibly powerful number, and it's about an incredibly powerful tool. Why are we working to capture the individuals with PBJs? Because all offender laws are the only thing that stop drunk drivers from reoffending. According to the CDC, ignition interlocks are effective in reducing repeat drunk driving by 67% while the device is installed compared to license suspension alone. Beyond immediate prevention, interlocks help save lives because they change behaviors. Research continues to show that drivers who have ignition interlock devices installed are less likely to have a repeat drug driving offense when using ignition interlock than drunk drivers who do not have an interlock device installed. By including individuals who receive PBJs for their first drunk driving offense, Maryland can help prevent more serious drunk driving accidents and fatalities down the road. We know Noah's Law is working. Third and subsequent offenses are decreasing. Now, let's preserve Noah's legacy, close this loophole, and ensure that individuals receiving a PBJ are prevented from drunk driving ever again. Maryland has been a leader on drunk driving prevention. And now that we've seen the life-saving benefit of these laws firsthand, it's time to address the one significant gap in our law and get individuals on their first drunk driving offense with a PBJ enrolled in our ignition interlock program. Last thing before I go, Mr. Chair, there is rightly always a discussion of ignition interlock costs when we talk about this issue. And along with you and Senator Carter and so many folks on the committee, I've worked hard to make sure we don't criminalize poverty in Maryland. And I don't want to repeat that in this bill. And that's why the MVA is working with the manufacturers to ensure an affordability program that works for all Marylanders. If you are already eligible for 14 programs, such as free lunches or Maryland Medical Assistance Program or SSI, that makes you automatically eligible for reduced price on these interlocks. And what that means is, on average, participants on the reduced fee program have a monthly lease rate averaging just $1.38 a day. And now the MVA is considering making a change to eliminate installation and removal fees that they typically charge as part of their services. And my understanding, Mr. Chairman, is that the manufacturers support this important increase in affordability. And with that, I ask for a favorable report on SB 672.
Excellent. Thank you, Vice Chair Wallstreicher. We'll now move on to your panel. I have Mr. Harris as your primary witness. And so, Mr. Harris, you're up next. You will have 5 minutes as the primary witness. Floor is yours. We'll get you unmuted here. There we go.
All right. Thank you, Mr. Chairman and members of the committee for allowing me to testify in support of this life-saving legislation. My name is Frank Harris. I'm the Director of State Government Affairs for Mothers Against Drunk Driving. And may I truly thanks to Senator Wallstreicher for authoring this life-saving proposal. In 2006, MAD took a step back to look at what works to stop drunk driving. And we really made a sea change. We made a sea change towards focusing on technology. And we did this because from 1994 to about 2006, there wasn't a significant reduction in drunk driving deaths like there were in the early 1980s when MAD was first formed. From 1994 to 2006, about 1 of every 3 drunk driving deaths were caused by a drunk driver. So what MAD was pushing for was not making a significant enough difference. And we found out the only way we're going to eliminate drunk driving is by technology. And that's why in 2006, we launched the campaign to eliminate drunk driving. And as it relates to our efforts in states, our top legislative priority since 2006 has been advocating for the use of ignition interlocks for every drunk driver, specifically passing an all-offender ignition interlock law like Noah's Law. And what we mean by all-offender ignition interlock law is that the only way someone can drive is if they have an ignition interlock on during either a court-ordered or DMV administered license suspension. And when MAD launched this campaign to eliminate drunk driving in 2006, only one state, New Mexico, had an all-offender ignition interlock law in place. Today, there are 34 states plus DC with these laws in place. Now, the senator already mentioned the effectiveness of these devices. It's been well studied, ignition interlocks. And again, the reason why MAD shifted towards technology is, license suspension, incarceration alone, especially license suspension, that is a hope for the best approach. Hope for the best approach is stopping drunk driving. We can't use hope to eliminate drunk driving. We need technology. And that's what this bill provides for. So just a quick recap, it's been 15 years since MADS launched the campaign to eliminate drunk driving. The Insurance Institute for Highway and Auto Safety has studied the mandatory ignition interlock law as well. They found that it reduces drunk driving deaths by 16%. And MAD ourselves, we reached out to the interlock companies and we found from 2006 to 2019, ignition interlocks prevented over 26 million attempts to drink and drive of any alcohol throughout the country, including 3.4 million attempts to legally drive drunk with a 0.08 or greater. This is a significant amount of drinking and driving attempts that have been prevented by this life-saving technology. And it is no surprise that over this 13-year period, that in the United States, drunk driving deaths have decreased by 25%. Now, there may not be a direct correlation, but there's some sort of correlation here. And something is happening in the states with the increase of interlocks, the drinking and driving attempts prevented by these life-saving devices. Because again, drunk driving deaths have dropped 25%, and that outpaces the traffic fatality reduction, which was only 15%. And I mentioned earlier that we launched this campaign to eliminate drunk driving because despite our best efforts, 1 in every 3 drunk traffic fatalities was caused by a drunk driver. Well, since we launched the campaign to eliminate drunk driving, for the first time in history, the percentage of drunk driving deaths relative to traffic fatalities has dropped below 30%. And it's remained below 30% since 2015. This is a big deal in traffic safety, but we still lose 10,000 people a year to drunk driving deaths. So MAD firmly believes technology and ignition interlocks preventing millions of attempts to drive drunk in our country has played a big role in reducing drunk driving deaths, and it should show lawmakers they should double down in ensuring that every single drunk driver uses an interlock. And MAD's not here to ruin people's lives. We're here to stop drunk driving, rehabilitate offenders. And PBJ, it provides individuals with a second chance. But the current scheme in Maryland, it sets up the folks on PBJ to become a repeat offender, and it sets them up for failure. That's why we really like this proposal to close that loophole to ensure interlock is used for all PBJ offenders. And again, the cost, there is an indigent program to alleviate the cost, but this is a right step in the right direction, good step in the right direction, and utilizes technology, which is going to be the way we eliminate drunk driving to further MAD's mission. So with that, we urge a favorable report on this legislation. Thank you.
Excellent. Thank you, Mr. Harris. And next, we will go on to Ms. Stimson. You're up next.
Good afternoon. Thank you, Mr. Chairman and members of the committee for allowing me to testify in favor of Senate Bill 672. My name is Robin Stimson. I am the manager for Mothers Against Drunk Driving Victim Services. MAD thanks you, Senator Waldstreicher, for sponsoring this critical legislation. You'll likely hear many stats and numbers during this and others hearings today. It is my hope after this testimony, however, you remember just 3 numbers: 100, 0, and 1. 100, because the crime of drunk driving is 100% preventable. 0, because for MAD, the number that matters is 0, 0 deaths, 0 injuries, 0 families impacted by impaired driving, which brings me to my last number of 1. 1 more victim of this crime is too many. Senate Bill 672 ensures that the intent behind the 2016 Drunk Driving Reduction Act, also known as Noah's Law, is followed. Noah's Law made Maryland one of 34 states plus the District of Columbia to have in place an all offender ignition interlock law. However, plea agreements or probation before judgments have allowed offenders to avoid using this life-saving device. All drunk drivers should be required to use an ignition interlock for a period of 6 months in order to drive after a drunk driving arrest. My role as a proponent for victims' rights has provided me the honor of supporting the survivors that have lost a loved one or have been injured as a result of these horrific crimes. Victims may come from different backgrounds, different stations in life, but they all have one thing in common. None of them ever want another person to suffer the pain and the loss that they have as a result of a drunk driving crash and another individual's poor choices. It is my privilege to advocate for them and walk with them, and that includes my presence here today. Ignition interlock devices are life-saving. They are the most effective tool we have to keep our roadways safe while providing the true second chance for offenders, while allowing them to maintain their independence and obligations. SB 672 addresses the 100, 0, and 1 numbers I just mentioned. MAD thanks you for your time and your attention, and I'm happy to discuss any of the above data if the committee would like more information. So thank you.
Excellent. Thank you, Ms. Stinson. Next, we'll have Mr. Erickson. You're up next.
Let me just unmute, excuse me. Mr. Chairman, members of the committee, my name is Kurt Erickson. I serve as president of the Maryland nonprofit Washington Regional Alcohol Program. You've heard a lot of stats. You've heard what the bill does. Let me just emphasize the need for it. And I see that the Motor Vehicle Administrator, Kirsty Neiser, I don't want to steal her of her thunder, but MVA just released as of last week, their annual Maryland's Ignition Interlock Status Report for 2020. In that report, it found out that nearly half, 40.4%, nearly half of persons adjudicated for either a DUI or a DWI, so a 21902A or a 21902B in Maryland in 2019, were granted probation in the form of probation before judgment and therefore not subject to the full universe of public protections, namely participation in Maryland's proven effective ignition interlock program. Senate Bill 672 simply looks to ensure public safety along that route used by nearly half of persons arrested for drunk driving in Maryland by subjecting all 21902A and 21902B offender to Maryland's interlock program as a condition of probation. That's all it does. NHTSA data, the National Highway Traffic Safety Administration data, shows that, quote, interlocks typically are used as a condition of probation for DWI offenders to prevent them from driving while impaired by alcohol after their driver's license has been reinstated, close quote. In a state where nearly a third, 32% of traffic fatalities still involve drunk drivers, not using Maryland's existing and offender-paid interlock program for the full universe of DUI and DWI offenders in a state is at best not using every tool in Maryland's toolbox to prevent drunk driving. At worst, it's potentially deadly, as 2019 also bore witness to Maryland posting a nearly 30% increase in the number of alcohol impaired traffic fatalities that year. So as a means of both effectively monitoring a drunk driver's probation period in Maryland and strengthening Maryland's Drunk Driving Regulation Act of 2016, otherwise known as Noah's Law, we respectively ask for your consideration of favorably reporting this potentially life-saving legislation. Thank you.
Excellent. Thank you very much. All right, next we'll have Ms. Neiser. You're up. There you go.
Good afternoon, Mr. Chairman and members of the committee. For the record, Christine Neiser, MDOT Administrator, and I also serve as Governor Hogan's Highway Safety Representative. I think the witnesses who have testified before me have already identified many of the statistics in Maryland. We certainly remain committed to our goal of 0 fatalities on our roadways. We all know that's the only acceptable number. And we believe it's a multi-pronged approach, and certainly one of it is ensuring we have strong legislative and regulatory measures in place, and this is certainly one of those. We're also focused on our statewide strategic highway safety plan, which has a strong impaired driving component, which is actually chaired by Kurt Kurt Erickson, who you just heard from. We're also looking at new technology, which Matt alluded to. You know, even in our state fleet, we've installed the driver alcohol detection system for safety, which stops somebody from starting a vehicle if they have alcohol in their breath. So really, we're looking at this from every aspect because we want to reach that goal of 0 fatalities. The reality, and Matt is a wonderful representation of this. You know, these are not just numbers; these are really people in our community. And I think Noah's Law, which passed several years ago, Mr. Liotta really captured our hearts. And unfortunately, in my role, I've had the honor of getting to know many of these families and the heartbreak that they carry with them for the rest of their lives. We know that PBJ may be looked at as something that's given for a first offense, but the reality is, and MAD data shows that, you know, the driver may have been driving 80 times impaired before they actually were arrested. The ignition interlock data also shows, and it's been mentioned before, the number of times, you know, over 3,000 times just in a year alone that somebody in the ignition interlock program attempted to start their vehicle while they were above the legal limit. I think it's really important to emphasize that because this is about changing behavior. You know, and talking to many of the folks going through the program, it really is about, you know, it's not just about driving. This is about changing their behavior and modifying their behavior to be safe behind the wheel. And so we believe ignition interlock, and the data proves that ignition interlock is a really successful way to do that. This bill would help add 6,900 participants in the program on an annual basis. And obviously, we believe that is a life-saving measure, which will make sure that when they do drive, they will be driving safely and not potentially harm to everybody else on the roadway. We thank the legislature for the action you've taken with Noah's Law. It really made a huge difference in terms of the number of participants in the program. We believe this is the next natural step forward, and we're happy to work with the legislature. We have done some things Senator Waldstreicher mentioned in terms of the incident program and provisions. We do have the ability to waive the licensing fee that they have to pay when they get that corrected license. And certainly we work with the manufacturers to provide annual reports to us on the action taken, but we look forward to working with the legislature on additional recommendations in that area. With that, I would ask for the committee's favorable consideration and be happy to answer any questions.
Excellent. Thank you very much. Good to see you.
See you.
Next, we'll have Mr. Murray.
He's not here.
Got it. All right. With that, that'll conclude the testimony for Senate Bill 672. Now I'll turn it over to the committee for questions. Seeing none. All right. Thank you all very much. With that, that'll conclude the hearing for Senate Bill 672. Thank you very much, Vice Chair Waldstreicher, and to all the panelists. Good to see you all. Have a great afternoon. Okay. Now we'll move on to Senate Bill 700, which is Senator West. Senator West, you're up.
Thank you, Mr. Chairman. It's let me start by saying it's great to see Senator Bailey and Senator Casserly and Senator Lee and Senator, who am I missing? Well, there are four senators who've been mentioned in the news. Oh, there's Senator Hedelman, of course. And I wish them the very best of health. I'm sure we all do. So once again, on Senate Bill 700, I've been working with the Estates and Trust section of the Maryland State Bar Association. And in fact, I have two witnesses this afternoon who hail from the MSBA's Estates and Trust section. This bill deals with what happens to a person's will after it's executed. Generally speaking, but not always, the attorney who prepared the will retains possession of the will after the signing. The current law gives little guidance, however, about custody of the will between its execution and the death of the testator. But sometimes things occur that call out for statutory direction. For example, what happens to the will if the attorney retires or dies? Suppose the attorney's firm wants to cease the practice of estates and trust law. Suppose the testator relocates and can't be found, and it's likely that due to the passage of time, the testator has died. Currently, the law allows an original will to be deposited with the register of the county where the testator resides, present tense. But suppose the attorney can't find the testator or ascertain where the testator currently resides. Senate Bill 700 tries to deal with these issues and resolve them. First, the bill establishes the general rule that any person other than the testator who has custody of a will has a duty to maintain custody of the will, and unless authorized by the testator, may not destroy or dispose of the will, may not disclose the contents of the will to anyone, and may not deliver the will to anyone except the testator. The bill then provides, as under current law, that the testator may deposit the will for safekeeping with the register of the county in which the testator resides, or alternatively, that any other person with custody of the will may deposit the will with the register of the county in which the testator resides, or with the register of the county in which the testator resided when the will was executed. The bill also provides that a person with custody of a will shall deliver the will either to the testator upon demand of the testator, to a court-appointed guardian of the testator's property on demand of the guardian, to an attorney in fact, acting under a durable power of attorney signed by the testator, which expressly authorizes the attorney in fact to demand custody of the will, or upon the death of the testator to the register for the county where the administration of the estate should take place. Finally, the bill states that a licensed Maryland attorney who has custody of a will may file the will with the register of the county where the testator resided when the will was executed, in the event that 25 years have elapsed since the execution and the attorney has diligently but unsuccessfully tried to ascertain the testator's current address. In such an event, the register, when the register receives the will, may destroy the will, but must retain an electronic copy of the will. The bill makes some other technical changes to the law, but that's the effect of it. It tries to answer lots of different questions about what should happen to a will between the time it's executed and the time the testator dies. I hope the committee will issue a favorable report on this bill, and Ms. Muffaletto and Ms. Hubbard both are here to talk briefly and then answer your questions.
Okay, excellent. Thank you, Senator West. And so I have Ms. Muff is the primary witness, and so you'll have 5 minutes. Sorry, it was written down that way. I see the full name there. Sorry about that. My apologies.
Totally fine.
The floor is yours.
Thank you, Mr. Chairman, Senator West, members of the committee. My name is Michaela Muffaletto. It's always shortened when you sign up as a witness to
Yes,
testify.
I'll get it right next time.
That's okay. I'm the chair-elect of the MSBA Estate and Trust Law Section. We're here today to request a favorable report on Senate Bill 700. As Senator West so eloquently summarized all of the details, I'm going to kind of reiterate some of that. This bill does a substantial revision to Subtitle 2, Article 4 of the Estates and Trust article relating to the disposition of original wills. Again, those are wills that are executed and before the person who signed it, the testator's death. This section of the Estates and Trust article currently is extremely limited and quite frankly outdated. It hasn't been updated in many, many, many years. The statutory changes found in Senate Bill 700 are intended to fill a lot of those gaps in the existing law. Currently, there are no provisions in the law with respect to the disposition of an original will by anyone other than the testator. That's the person who made the will or the testator's agent, as long as the testator's alive. Senate Bill 700 expands the class of persons who can dispose of an original will to include anyone who's in custody of that will. Because a lot of people lose their wills, people no longer maintain their safe deposit boxes at local banks. Oftentimes, we as attorneys who prepare wills are asked to be the custodian of those wills. The current law doesn't provide us with a whole lot of alternatives for what we can do when wills are old and we know that they've been replaced, but or perhaps the testator has gone to another attorney, or when we don't know where they live anymore, or even if they're still alive. for attorneys who safeguard wills, like Senator West alluded to, and they either retire or pass away. There's a whole host of additional problems that are created by that. Attorneys and their successors tend to get creative in their solutions that are not necessarily permitted by the law and that may not adequately safeguard the testator's wishes. We think Senate Bill 700 provides solutions for these issues. It authorizes any person in possession of an original will to deposit it in the Register of Wills of the county where the testator resides currently or where the testator resided when the will was executed. It also gives authority to the guardian of a testator or an agent acting under a valid power of attorney to make a demand for the testator's will from a person who has custody of that will. Senate Bill 700 also provides options to attorneys like myself who safeguard wills for their clients. For wills that are 25 years old or more, and an attorney can't locate the testator, they have the option of completing a specific certification and depositing that will with the Register of Wills office. The register can then continue to maintain the original if they choose, or this law would allow them to destroy the original, maintaining an electronic copy on file along with the certification. Also, an attorney in possession of a will that's 10 years after the testator's death, where there's been no probate of that will, the attorney would be authorized to destroy that will under the assumption that no probate will ever be needed if one hasn't been needed for 10 years. We believe Senate Bill 700 fills many gaps in the existing law. We believe that it'll provide greater access to justice for Marylanders, helping them ensure that the original wills that they've executed are safeguarded properly. It'll also eliminate the guesswork in trying to locate these wills. For these reasons, we would ask for a favorable report from the committee on Senate Bill 700. Thank you.
Excellent. Thank you very much. And next we'll have Ms. Hubbard. You are up.
Thank you. Good afternoon. My name is Christine Hubbard, and I'm testifying on behalf of the Maryland State Bar Association Estate and Trust Law Section in support of Senate Bill 700. This is a housekeeping bill. It simply lets people know how to handle original wills when they cannot find the testator and how to locate wills when they're looking for them. May I ask you to picture a 75-year-old attorney who is just about to retire, finally. She's sitting at her desk with her hand on a stack of original wills for which she cannot find the testator. She picks up one and sees it's Jane Doe's will. She looks at the back. It's beautifully signed, witnessed. It's even self-proving. She flips through. She sees that Jane Doe wants her mother's engagement ring to go to her granddaughter, her father's military memorabilia to go to a particular son, and her remaining desires are beautifully expressed. Well, that lawyer can't find the testator, can't find Jane Doe, as I said, and can't do anything else with that will. She checks the law, double checks the law. There's no guidance there. Tries to find another attorney to take it. Hey, I'm retiring. Nobody wants to take it because those lawyers, they don't know what to do with it either. So that will, along with the rest of the stack, gets put into a safe in the back of that lawyer's garage and is forgotten about. When Jane Doe dies, Jane Doe's family hires a lawyer. We know mom has a will. She talked about it. She told us what was in it. Well, the will can't be found. That poor family now has to go through a costly and inefficient intestate proceeding. Worst of all, Jane Doe's carefully crafted last intentions, last desires cannot be honored. So Senate Bill 700 allows that lawyer who's looking to retire to file the will with the Register of Wills where Jane Doe lived or where she signed it where she lived when she originally signed it. Then there's a registry all over Maryland, because the registers of wills, when somebody records their will with them, it's on a registry. So Jane Doe's family can go to any register of wills and say, hey, where's Jane Doe's will? And they can readily find it. As stated, it also provides common sense guidance as to how wills unlikely to be ever probated can be disposed of. So in sum, this is a housekeeping bill. It's not a tough one. It allows people greater access to justice. That's our job. By helping to ensure that these wills are safeguarded, they're not lost, and that the testator's final wishes are honored. For these reasons, we ask that you vote favorably on House Bill 700. Thank you.
Thank you, Ms. Hubbard. It was fantastic testimony all the way up into the end, because this is the Senate, but all good. I'm joking. Well, thank you very much. With that concludes the testimony for Senate Bill 700. Looking to the committee for questions, and we have one for Senator Castley. Hold on, let me grab you here. Hold on. There you go.
Just really briefly, I guess maybe to Senator West, but or the bar folks. Is this unanimous? The bar committees, there's no opposition. Your bar committee is totally unanimous for this. And
Senator, I'll let the witnesses answer that definitively, but in general, generally speaking, each of these substantive section chairs or executive councils represent the entire panoply of lawyers from one station to the other that practice law in that area. And when they have a legislative committee, similarly, the members are drawn from all the sectors that practice in that area. So I'm going to let Ms. Muffaletto answer the question specifically. I would be shocked to find that there was serious disagreement in the Estates and Trust section about this bill.
Senator West, thank you. You are correct. Within the section, we have a section council that reviews all matters that our section does. And as a subset, we have a legislative committee of which I am luckily the chair of, along with being the vice chair of the entire section. So this bill has been vetted and drafted and redrafted by our legislative committee, reviewed by our section council members. It has been voted unanimously in favor. So that's why we're here asking for your support as well.
And could I also mention that it has also been presented to the registers of wills and the orphans court judges. They like it. There has been no opposition whatsoever. So they're all on board as well.
Good point.
Thank you all. Appreciate it.
Excellent. Thank you, Senator Castley. Seeing no further questions from the committee, thank you, Senator West, and thank you to Ms. Muffaletto and Ms. Hubbard. And with that, that'll conclude the hearing and the testimony for Senate Bill 700. All right, next we'll move on to Senator Bailey with Senate Bill 617. Senator Bailey, you're up.
Thank you very much, Mr. Chairman, members of the committee. So we can actually kill two birds with one stone, because Senate Bill 617 and Senate Bill 702 that Senator West has just following this, they are the exact same bill. So I will go through my explanation, and Senator West, you jump in at any time that you see fit. So this bill deals with criminal procedure, sexual offenders, lifetime supervision. Senate Bill 617 provides that a person is not entitled to expungement if the court ordered the person to register as a sex offender as a result of the charge on which the petition for expungement is based. That's one thing that applies in the bill. Second, and separately, the bill adds that individuals who have not satisfied an obligation to pay court costs, fines, or restitution imposed by the court in connection with the disposition of the charge on which the petition is based. So if they still owe the court money, then they can't get an expungement. It is my belief that Senate Bill 617 will help to protect Marylanders, in particular, prohibiting registered sex offenders from having their criminal records expunged is important to ensure that these offenders, particularly those who have committed sexual offenses against our children, cannot circumvent the registry, which is intended to keep our residents safe from these offenders. This is particularly important because those who commit sexual offenses against children have a higher rate of recidivism than those who have committed other crimes. This bill would also ensure that these convicted criminals pay their full debt to society before they're eligible to have their criminal records expunged. I respectfully request a favorable report on Senate Bill 617.
And Mr. Chair, I think I'm still unmuted. So let me just say that I agree with every word Senator Bailey just said. And as far as I'm concerned, if you want to pass Senator Bailey's bill and just put me down as a co-sponsor, I'm perfectly happy to accommodate.
Thank you, Senator.
Okay, excellent. All right. So with that, we'll move on to the panel. And Senator Wesson Bailey, I have Mr. Cox as the primary panelist. So we'll go on. Mr. Cox, you'll have 5 minutes as the primary. Good to see you.
Thank you, Chairman Smith and Vice Chair Waldstreicher and members of Judicial Proceedings. Am I being heard? I guess so. I want to thank Senator Bailey and Senator West for both being brilliant enough to come up with the exact same language to address this particular issue. And it is an issue that I feel is important in the unique circumstances where we are. As I know, all of you know, there are two primary statutes addressing expungement. One of them is Criminal Procedure 10-110, which the General Assembly has worked on for the last 4 or 5 years to address a number of the guilty findings that are eligible for expungement after a number of years. Honestly, the amendments here are not necessary for 10-110 because 10-110 has built within it a requirement that the court find that it is in the interest of justice to grant the expungement. Frankly, the arguments about being on the sex offender registry or not paying their costs or their restitution is something that I think we can argue is not in the interest of justice to grant expungement. So the only problem that's created is in 10-105. 10-105 primarily has some very minor guilty findings, which again, I'm not that concerned about. But the biggest issue is the probation before judgment. With regard to the sex offender, this issue first came up or came to my attention when we had a circumstance where the state of West Virginia called us and said, why do I have to take this guy off the sex offender registry? We had a case that we prosecuted. It was a sexual offense on a child because of the child's inability to walk into a courtroom and articulate what had happened to her. We had to work out an agreement where the defendant was pled guilty to a 4th-degree sex offense and got a probation before judgment. In that circumstance, under the sex offender registry, the court has the discretion to decide whether or not that person goes on the registry if it's a probation before judgment. And in this circumstance, we argued the issue and the judge decided that this person should be on the sex offender registry. He moved to West Virginia and was required to register there. He then applied for, because it was a probation before judgment and 3 years had run, he applied for and got an expungement. We had no ability to fight that or stop that. And so his probation before judgment 4th-degree sex offense was removed. There was no more record of it, including the order that he register as a sex offender. And therefore, West Virginia had no choice but to take him off of the sex offender registry. This would address that unique circumstance. It is relatively unique with the sex offender registry because most of the offenses, you're not even eligible to get a probation before judgment. But 4th-degree sex offense, you are. And that's where our problem comes. So we're asking that you add an exception to the ability to get the automatic expungement and require that if they're on the sex offender registry, they not be allowed to get the expungement until they're no longer on that registry. The other issue is frankly cost. And I did note, Chairman Smith, that apparently Chief Judge Morrissey wrote you a letter on January the 14th, along with Pam Harris, the state court administrator, expressing concerns about expungements for circumstances where the person still owes court costs. Frankly, and actually more importantly, is restitution. So say, for example, if an individual gets a probation before judgment for a theft where they stole a significant amount of money from somebody, the judge will order them to pay that in restitution, will probably give a judgment of restitution. If they get the probation for a judgment, they can come in 3 years later. If they've not committed another crime in that time period, it's automatic. They have to get that case expunged. The judge doesn't have a choice. And in that circumstance, it wipes out that judgment of restitution. Our victims no longer have the ability to prove that they're owed this money. And then it creates, obviously, a very significant difficulty. The same is true for all the court costs. If somebody hasn't paid their court costs, hasn't paid their fine, and gets their conviction or their probation for judgment expunged, then that wipes out what is owed to the state. I was a little bit surprised by the fiscal note saying that there was no impact on revenue, because unquestionably there are circumstances where somebody has a case expunged who never paid their court costs or never paid their fines, and therefore it's costing the state money in not being able to collect those that have been ordered by a judge. I know that there ought to be some concern about an individual who's financially unable to pay, and I certainly don't want this to be a circumstance where somebody who's indigent is denied an expungement when anybody else is granted one. There are other revenues or avenues available. A judge can make a determination at the beginning that they don't have the ability to pay and not order the cost or the fine. And in addition, if the individual were to come back and ask a judge to waive that requirement, they certainly can do so. So I think that it ought to, or I would hope to address that issue. But these are two pieces where there is no choice to grant that expungement, and it's two areas where I think it's important that the expungement not be granted. And I appreciate your attempt.
Excellent. Thank you very much. All right. Next, we will have, that's the concludes testimony for the proponents. We'll go to the opposition panel. Mr. Dews, you're up first.
Indeed. Thank you, members of the committee, for having me. My name is Christopher Dews, and I'm a policy advocate for the Job Opportunities Task Force. Our mission, of course, is to help lower wage workers advance to higher wage jobs. Mr. Cox actually already acknowledged what our biggest concerns with the bill are and why we're voting really unfavorable with amendments. And that is that if a person does not have the ability to pay certain fines or fees that are imposed by the courts, then they are just generally locked out of expungement. So our biggest concern is, we know this, a criminal record can be both the cause and consequence of poverty. And according to the National Employment Law Center, 25%, up to 25% of Marylanders have some type of criminal record that can show up on a background check. So what we don't want to happen is that people are locked out of employment because they cannot expunge a record specifically for their inability to pay a fine or a fee. And so then, they just never are able to accumulate the money because they don't have access to employment, and they don't have access to employment because they can't get rid of the record, and they can't get rid of the record because they don't have access to money, which they don't have access to money because they don't have access to employment. You already see how this game goes. So, I mean, I actually will say less. I do want to mention that our issue with the bill has nothing to do with, as Senator Bailey mentioned, and also as Senator West mentioned, the sexual offense. That's an entirely separate issue that we want to address as well, but in a separate bill. And our issue is also not necessarily with restitution that is being paid back to victims. We just want to ensure that if a person is indigent and they do not have access to financial capital to be able to pay a specific court-ordered fine or fee, that they are not then locked out of expungement. And we are willing to work with the bill sponsors to make sure that that happens, though we understand the rationality as to why the bill is coming to being. So I'm going to say less. I'll just say that we are currently opposed to the bill without any amendments, specifically looking at the inability to pay. For those reasons, we ask for an unfavorable report unless we can have a conversation with the sponsors. Thank you for your time.
Excellent. Thank you, Mr. Dews. Next, we'll have Mr. Sweeney. Is Mr. Sweeney here?
He's not here.
Okay, great. Then we'll move on to Ms. Hanson. You are up. Unmute. There you go.
Can you hear me now?
Yes, we can.
Okay, thank you. Mundell. I am the executive director of Out for Justice, a nonprofit organization based in Maryland of individuals formerly incarcerated have decided to change our lives and pay close attention to the legislative process. I won't repeat, the arguments from Chris. Chris's arguments are directly connected with our concerns of the bill, especially as it relates to these fines and fees, right? We had we have momentum happening in the legislature right now around how these fines and fees are hurting, Americans, but more importantly, are hurting everyday Marylanders, right? And that they cannot kind of get out of this cycle of poverty because of all of these mandated fines and fees. And, the argument is, and the sentiment is in my community, is that, Maryland is operating its state off of the backs of poor folks. And that is just not right. And I know this is not something that this legislator wants to give off. The other thing, most people don't want to get into the sexual offenses and the rigmarole of that. It's a very controversial topic. However, because I represent all of those people, I would caution you all from, not looking into these special cases, right? There are so many men and women. We had a case in our all-night clinic a few years ago where a woman was caught up in the sex trafficking trade, and her abuser, kind of forced her to engage in these situations, and she came out of that with a sex offense, right? Because her abuser was forcing her to, go along with these horrible things that he was doing in terms of trafficking women and the like, and she came out of that with a sex offense. The same thing, we have young people who are engaging with each other, and the guy may be 17 or 18, and 15, and we have situations where people are very close in age, but because parents may choose to file charges, this young man or this young woman who's slightly older somehow ends up on the sex offense registry. So I just ask us to dig a little bit deeper and not lump all of these sex offenses in one category, and really do the hard work of researching and being strategic around which of these offenses are you all. I mean, at the end of the day, my position is that once the person has done their time, right, and they have served their debt to community, and the law allows for their record to be expunged,
Ms. Hanson,
Thank you.
Thank you very much. Thank you. All right. With that, then we have, is Ms. Davis here? I don't see Ms. Davis. Oh, there you go. There she is. Ms. Davis, I'm going to ask to unmute you. Here you go.
No,
There you
I'm
go.
unmuted.
We can hear you.
Okay, perfect. Thank you so much. I'm here today from the Office of the Public Defender, and I am here to ask for an unfavorable report on Senate Bill 617. What I would say from my experience of expungement law is that expungement law has always been viewed as an avenue for the citizens of Maryland to move forward with their lives, for themselves and their families. It allows change to be made, mistakes to be rectified, wrong behavior to be reformed, which all leads them to becoming a more productive member of their community. I believe that this bill is a step in the wrong direction. It's moving backwards in its approach against all the progress that has been made recently in the years by the legislature. It imposes a cloud of consequences that I'm sure are not intended. For example, the U.S. Census Bureau had a report recently that said 9.4% of the state's population are living below the poverty line, which is close to 500,000 Maryland citizens. It also shows that 13.6% of people of color in Maryland are living below the poverty line. The Justice Policy Institute in DC conducted a study, and that report came out last year, in which it says that Maryland prison population is more than doubled than any other state in the country when it comes to people of color. And the Maryland prisons population currently is 70% when it comes to people of color. This is just one example of this bill of how it will be harmful. Because if you put the numbers together, simply put, how can someone move forward if their poverty is holding them back? I also believe that the expungement statute should not be utilized to further punish an individual. There's enough laws that we punish people, and there's other remedies that will address the concerns that the legislators have of why they introduced this bill. So for that reason, the OPD and I would request that the bill receive an unfavorable recommendation.
Excellent. Thank you, Ms. Davis. And we do have one final witness for the opposition. Abigail, is Abigail here?
She is not.
Okay, got it. All right. So with that, that'll conclude the testimony for Senate Bills 617 and 702. Turn it over to the committee for questions. Okay, seeing none. Excellent. Thank you, Senator West. Thank you, Senator Bailey. Thank you to the panelists. And so that'll conclude the hearing for Senate Bill 617. We'll now move on to the final bill of the day, Senator Huff with Senate Bill 712.
Thank you very much, Mr. Chairman. This was a bill that we've heard numerous years. Actually, I want to first thank the chair for giving us a vote last year. It was the first time many years had a vote, and it died by a mere 6-5. And given that we have a new member on the committee, maybe some people have changed their minds, I wanted to bring it back this year. Senate Bill 712 will return to motorcycle enthusiasts the freedom to ride without a helmet if they meet certain requirements. First, let me say this is a personal liberty issue. There are lawful activities that we allow adults to engage in that are inherently risky. Activities like hunting, driving, skydiving, riding a motorcycle itself is inherently risky, yet it is a lawful activity that we allow adults to engage in. The bill allows for greater freedom while retaining some requirements for motorcycle riders. Namely, riders would need to be at least 21 years old, have 2 years of riding experience, and have completed a motorcycle safety course before they ride without a helmet. I want to use this quote. I used it last year. It's from On Liberty by political philosopher John Stuart Mill. I think it really gets at the heart of what this is about. That the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not a sufficient warrant. He can rightfully be compelled to do or forbear because it will be better for him to do so, because it'll make him happy, because in the opinion of others, to do so would be wise or even right. To sum that up, we should be making laws not to protect people from themselves, protect them from others, not to make decisions for them. Most of us have never or may never ride a motorcycle. Therefore, we should not substitute our own judgment for the men and women who you'll hear from who regularly ride and want the freedom to choose whether or not to wear a helmet. As Mill says, we do not have sufficient warrant to compel them to do so, to compel them what we think is better. Beyond the philosophical argument, I want to provide you with some statistics. Maryland is in the minority of states that require all riders to wear a helmet. By contrast, 3 states, Illinois, Iowa, and New Hampshire, have no motorcycle helmet laws at all. 28 states require only some motorcyclists to wear a helmet, typically for younger riders like this bill. 3 states, Michigan, Pennsylvania, and Texas, have similar laws to this bill. You will hear today from opponents who will try to paint a scary picture of what will happen if we change our motorcycle helmet laws. However, I would ask you to consider our neighboring state of Pennsylvania. It is twice as big as Maryland in size and population, has the exact same type of helmet law that this bill would require. Pennsylvania has not experienced the kind of problems with motorcycle helmet laws that critics describe. Data from the Governor's Highway Safety Association, in 2017, there were 86 fatalities in Maryland. 118,227 motorcycles are registered in Maryland. That equals a fatality rate of 7.3 per 10,000 registered motorcyclists. In Pennsylvania, which has a significantly larger population, there were only 187 motorcycle fatalities out of 377,000, 158,000 motorcycles. That equals a fatality rate of 4.9. So again, ours was 7.3. Pennsylvania, which has this law that they're going to decry, is only 4.9. Illinois, which has no helmet law, has a fatality rate of 4.8, and compared to Maryland, 7.3. Looking through years of statistics, there is no discernible pattern. Yes, there'll be some states that have no helmet law that may be higher than Maryland, and others that are lower. Adults in Maryland should be able to make their own decisions on whether they want to wear a helmet or not. 31 states allow for some measure of motorcycle freedom for riders, and we should join them. Passing this bill will not endanger public safety. It will not it will return to motorcyclists over the age of 21 who've driven for at least 2 years and have taken a safety course the freedom to choose whether they want to wear a helmet or not. I ask for a favorable vote on Senate Bill 712.
Excellent. Thank you, Senator Huff. And so your witnesses, you've got Mr. Sawyer, you're the primary witness, and so you'll have 5 minutes. You are up next. Mr. Sawyer, there you go. Let's try this one more time. There you go. I think you're unmuted.
All right.
There you go.
Thank you, Mr. Chairman and members of the committee. Good afternoon. For the record, my name is Kenneth Van Sawyer, Director of ABATE of Maryland and a voting resident of District 27B. I represent ABATE of Maryland. We are Maryland's largest motorcycle rights organization. Thank you for taking the time today to hear testimony on Senate Bill 712. ABATE of Maryland has worked to try to restore the freedoms of choice that have been taken from motorcycles in Maryland. A brief history. In 1966, the federal government forced the states to mandate helmet laws in order to receive federal highway funding. Over the next 8 years, Maryland and 46 other states implemented mandatory helmet laws. In 1976, the federal government loosened its position and states began repealing helmet laws, including Maryland. In 1991, federal government created incentives again for states to pass Maryland helmet laws. States began enacting helmet laws, including Maryland. In 1996, the federal government again revised itself and states again began repealing the helmet law, but Maryland has not yet repealed the mandatory helmet law it passed in 1992. This bill has been presented numerous times. The opponents to providing helmet choice cite safety as a reason for mandating helmet laws. We believe proper training reduces crashes, in turn reducing injuries. Setting aside the safety arguments, we believe adults should be able to make the choice for themselves whether or not to wear a helmet. The Motorcycle Rights Foundation and the American Motorcycle Association, the two largest motorcycle rider organizations in the country, support helmet choice. Jay Jackson, the Vice President at MRF, wrote to you that Senate Bill 712 is in alignment with the two key principles that MRF strongly believes in: personal freedom and crash avoidance over creating safer crashes. In his testimony to you, Attorney Jay Block informed you how ABATE of Maryland worked to initiate the Maryland Motorcycle Safety Program, which taught individuals how to ride a motorcycle, how to interact with vehicles and traffic, and how to minimize injury. This program has been credited with the reduction of all kinds of injuries, not just head trauma. You have written testimony from several other members. State Legislative Representative Emeritus Steve Strohmeyer submitted testimony to you pointing out the economic consequences he sees living near the Maryland-Pennsylvania border. He witnesses motorcycle riders leaving Maryland to enjoy helmet choice in nearby Pennsylvania. ABATE member Angie Sawyer also wrote to you about how her and her friends plan their weekends and vacations around motorcycling. Sometimes they enjoy the freedom of not wearing a helmet, and other times they keep their helmets on. It depends on factors such as weather, traffic, speed, or road conditions. Calvert County Assistant Director Dean House submitted statistics calling into question the numbers that our opposition provides. Just because ABATE of Maryland and other organizations are against mandatory helmet laws does not mean we're against helmet use. We believe that riders are in the best position to make this determination and should have the ability to make that decision. ABATE of Maryland is not a radical group. We're not troublemakers riding unregistered motorcycles, ATV, dirt bikes on the street, or causing chaos by disrupting the flow of traffic on the Beltway. We are responsible adults that enjoy the freedom of the road. Our ranks include lawyers, small business owners, military personnel, and legislators in this body. We are perfectly capable of making an informed choice regarding our safety. ABATE members want to restore the freedom of choice that so many other Marylanders are afforded. Please support Senate Bill 712 with a favorable report. Thank you, Mr. Chairman and members of the committee.
All right, thank you so much. Senator Huff, who is your next witness? Sandy, can you unmute
Okay.
yourself, please? There you go. Thank you. Or you can just call on the next witness, Sandy.
Jay Jackson is next.
All right. Mr. Jackson.
About now.
There you go, Mr. Jackson. Go ahead.
Thank you very much. Thank you, Chairman Smith, members of the committee. My name is Jay Jackson. I'm the Vice President of the Motorcycle Riders Foundation based in Washington, D.C. On behalf of the Motorcycle Riders Foundation, thank you for the opportunity to share our views on the proposed new law regarding motorcycle headgear. We support Senate Bill 712 and applaud the efforts of Senator Huff and the co-sponsors to address this issue. The MRF is a national organization focused on providing leadership at the federal level for state motorcyclist rights organizations, motorcycle clubs, and individual riders. The MRF is concerned with national and international issues that impact the freedom and safety of American street motorcyclists, while also supporting the efforts of our state partners. We're committed to being national advocates for advancing motorcycling and its accompanying lifestyle, and work in conjunction with a variety of partners to help educate elected officials and policymakers. Motorcycling is something that's enjoyed by over 8.6 million Americans and more than 118,000 Marylanders. With our network of about 250,000 motorcyclists nationwide, and on behalf of our members in Maryland, we support SB 712 because it recognizes that motorcyclists that have experience and the appropriate training have a right to choose for themselves whether they want to wear a helmet. Passage of SB 712 would demonstrate two key principles of the Motorcycle Riders Foundation that we strongly believe in: personal freedom and enhancing and emphasizing crash avoidance over creating safer crashing. By focusing on education rather than on government mandates, SB 712 promotes learning how to safely operate a motorcycle rather than punitive action against those that desire not to wear a specific piece of apparel. In doing so, motorcyclists can gain information about riding gear, techniques, and strategies that will allow them to make informed decisions regarding which safety measures they deem most appropriate for their riding style. Additionally, motorcycle education helps further enforce the crash avoidance over safer crashing philosophy. We should strive to reduce crashes. In a crash that never happens, there isn't any injury. The statistics regarding effectiveness of state helmet laws are ambiguous at best. A 2014 NHTSA study has shown that helmet usage in crash data in where helmet usage was known, 39% of the motorcyclists killed were not wearing a helmet. So conversely, that indicates that 61% of the riders fatally injured were wearing a helmet. Interestingly, a 2017 NHTSA study showed that the state with the highest motorcycle fatality rate had a mandatory helmet law, while the state with the lowest fatality rate does not require a helmet for those over 18 years of age. It's also important to remember that the absence of a requirement does not prohibit anyone from wearing a helmet. In fact, a 2019 U.S. Department of Transportation audit showed that states without mandatory helmet laws still saw at least 56% of their riders choosing to wear a helmet. So passage of SB 712 wouldn't force any Marylander to ride without a helmet. It would only allow each rider to decide for themselves. Thank you for your time, and I'd be happy to answer any questions.
Thank you, Mr. Jackson, for your testimony. Ms. Pop, who do we have next?
Janet Balhuth?
Pretty close.
Go ahead.
Hi, good afternoon. I'm Dr. Janet Bayhuth. I hold a PhD in transportation safety engineering, and I am clinically trained in injury biomechanics. I'm here to oppose this bill. First, let me tell you, I agree with some principles held by the supporters of the bill. I understand the love of riding, the sense of freedom, relishing the fresh air, and even the cool factor. And I absolutely agree, education and crash avoidance are key. But ask any rider, and if they're being honest, they'll tell you it's not a matter of if they'll crash, but when. I think you'd be surprised to know that a typical crash lasts 350 milliseconds. That's a third of a second and faster than the blink of an eye. The forces sustained during only a fraction of a second either ends a life, drastically changes it, or isn't enough to compromise the body due to safeguards like seatbelts or airbags or helmets. These safeguards actually extend the time and limit the force that is inflicted on a body. The longer a force is applied and the more force absorbed by the safeguard, the better your chances of walking away. That's the physics we can't ignore. So how does head injury happen? There are 3 events. First, the impact itself, possibly causing a fracture, followed by the brain's acceleration and the impact with the skull, leading to concussion, bleeding, or worse. And finally, the rotational force that twists the brain, causing tiny little shears in that brain matter. Guaranteed injury. Our research has shown that there are copious numbers of crashes involving only a motorcycle that go unreported. No one knows how many there are because they go unreported. Why? Because the rider gets up. He dusts himself off and goes on his way. And remember, he was in Maryland wearing a helmet. Take that helmet out of the scenario, and it's the physics that fosters injury and death. The supporters of this bill have implied that no one but the rider gets hurt. Actually, the taxpayers' economy and societal costs are hurt when we foot the $12 million bill for each death on our roads. And I'm not sure the driver of the car who killed the motorcyclist would agree that he's not hurt. That's simply inherent with causing someone's death. Knowing that a helmet could have prevented it seems to hurt more than the supporters of this bill would have you believe. And I'll conclude with this. By changing the all-rider helmet law, you are knowingly facilitating a rise in deaths that otherwise would not be. I urge you to oppose this bill. Thank you.
Thank you for your testimony and for the committee. We're obviously on the opponents now. Next is Mr. Mather. Mr. Mather, please go ahead.
Thank you so much, Mr. Chairman and members of the committee. I'm Dr. Jack Mather. I am the co-chair of the Legislative Committee for TraumaNet and the Medical Injury Prevention and Policy at the R. Adams Cali Shock Trauma Center. But first and foremost, I'm a trauma surgeon. And ultimately, at its most basic level, the conversation this afternoon about helmet use begs the question, how willing are we to risk the lives of our fellow Marylanders? 2017, there were almost 5,200 motorcyclists killed in the United States, yet less than 2% of those deaths occurred in the state of Maryland. Moreover, 40% of the motorcyclists killed nationwide were helmetless. While in the state of Maryland, due in large part to universal helmet laws, that figure was less than 15%. Maryland also saw slightly more than 5 deaths per 10,000 registered motorcycles. South Carolina, in comparison, which has a similar number of motorcycle registrations, but partial helmet laws, their rate of fatalities is more than twice as high. This bill also implies that age is an important variable, yet when comparing a young age group of 16 to 20 with an older age group of 21 to 55, the mortality rates are effectively the same, but are actually dramatically increased in states with partial helmet laws. There's also no evidence currently that rider training decreases these rates. To put it simply, partial helmet laws kill more motorcyclists irrespective of age. And choice alone is not effective. Helmet use is often over 90% in states with universal laws, but closer to 50% in states with partial laws. Our testimony, therefore, is in opposition to Bill 712. Helmets reduce the risk of death by 37% and the risk of traumatic brain injury by almost 70%. And failure to use a helmet can turn an otherwise inconsequential injury into major bleeding in the brain requiring brain surgery. Lifetime care for even a single patient with a serious traumatic brain injury can amount to millions of dollars. And if saving lives alone is not sufficient, then consider the economics. If all motorcyclists in the United States wore helmets, we could save more than $1 billion annually. And with annual medical costs of unhelmeted riders likely over $250 million, it's easy to imagine how the cost of healthcare to Marylanders will increase with this bill. So ask yourself today as you consider this bill, what benefit of not wearing a helmet is so great that it outweighs the increased risk of death and economic burden to Marylanders, especially during a global pandemic? And respectfully, Senator Huff, skydiving requires a parachute and driving requires a seatbelt. So I thank you for your time and I urge you to oppose this legislation. Thanks.
Thank you, Mr. Mather. Ms. Kennedy, you're up next.
Great, thank you so much. Good afternoon. I am Allison Kennedy, a resident of Hyattsville and Director of Government Relations for Advocates for Highway and Auto Safety. Thank you for the opportunity to provide written testimony and remarks in opposition to this bill from advocates, the Maryland State Council of the Emergency Nurses Association, and the Partnership for a Safer Maryland. Last year, despite reduced traffic on roadways due to the effects of COVID-19, risky driving behaviors such as speeding, impairment, distraction, and lack of seatbelt use all spiked, and an uptick in the traffic fatality rate and total number of fatalities ensued. This tragic trend was seen across the nation, including here in Maryland. It is well known that motorcycles are already the most hazardous form of motor vehicle transportation. And motorcyclist fatalities in Maryland are on the rise, having increased 21% from 2018 to 2019, amounting to 75 deaths. With our roads at a heightened rate of danger, removing the known life-saving motorcycle helmet law would drive Maryland down a destructive and dangerous path towards more preventable deaths and injuries. Laws requiring all riders to wear a motorcycle helmet are the only effective strategy in getting riders to do so and curb these needless fatalities. According to data from the latest year that it is available, helmets saved 43 lives in Maryland. Nationally, unhelmeted motorcyclists make up nearly 40% of all motorcyclist fatalities when helmet use is known. In sharp contrast, Maryland's average is 15%. This figure is remarkable, especially compared to our neighboring states that do not have an all-rider helmet law, which have significantly higher averages of 53% in Pennsylvania and 41% in Delaware. These statistics prove that our law is working to ensure motorcycle helmet use and is saving lives. All-rider helmet laws also conserve the state and taxpayers' money. Maryland saved nearly $600 million in comprehensive costs associated with motorcycle crashes because of helmet use. Conversely, Pennsylvania and Delaware are leaving potential substantial cost savings from comprehensive helmet use on the table. Lastly, given the ongoing burdens on our healthcare system from the pandemic, we must do all we can to keep road users safe and out of emergency rooms. Repealing the all-rider motorcycle helmet requirement, a proven lifesaver and injury preventer, will result in more strain on first responders and ER nurses and doctors whose efforts have been heroic. Advocates, MDENA, and the Partnership for a Safer Maryland urge an unfavorable vote. Thank you.
Thank you for your testimony. And the final witness of today, Mr. Lickenstein.
Hello, my name is Dr. Richard Lichtenstein, and I'm here today representing the Maryland chapter of the American Academy of Pediatrics in opposition to Senate Bill 712, which provides criteria for exempting motorcycle riders from wearing helmets that are over 21 years of age and have completed a particular safety course. I'm also a pediatric emergency medicine physician who's been working in injury prevention for more than 2 decades and can provide firsthand experience that helmets protect from head injury and save lives. First, I would echo the sound reasoning and data for why the bill is a bad idea that you've heard from other opponents. The human and economic costs are real and are well presented in oral and written testimony, which I urge you to read. However, as a pediatrician, I'd like to present 2 additional clear reasons for opposing this legislation, which might seem odd as the bill is aimed at riders 21 years of age and higher, and I'm a pediatrician. We already have experience with minors-only helmet laws, such as Senate Bill 712. In short, experience shows that the consequences of such legislation are severe, such as Florida's 188% increase in mortality in unhelmeted children under 21 when their universal bill was changed in 2000. Also, from a developmental perspective, children model what they see, and so it would not be surprising that increasing numbers of helmetless adult riders would be akin to providing approval of this dangerous practice for minors. This unintended consequence is real, as demonstrated by data from other states, and should be prevented. In my field, life would be so much easier if the tenets of this bill were true. In other words, if I received training for my driver's license that had 2 years experience on the road, I could safely make this decision for myself and my passengers not to be buckled up or be restrained in car seats. However, the tenets of this bill are not true. No one can argue that seatbelts and car seats don't save lives regardless of the skill, experience, and training of the driver. The same is true for motorcycle helmets. The reality is that even those of us with skill, experience, and training are constantly challenged by the unknown and the unexpected. The hidden ditch in the road, the erratic behavior of another vehicle, or changes in weather, or even personal lapses in good decision-making. The analogy is accurate for motorcycles too. Our current law is working and shouldn't be changed. The universal wearing of a motorcycle helmet to protect the precious cargo of parent, grandparent, child, or friend is a sound investment, and thus we urge you to oppose Senate Bill 712. Thank you.
Thanks, Mr. Lichtenstein. You and I both have CHs in our name that no one knows how to pronounce. With that, I'll look around the committee room to see if there are any questions, if anyone wants to use the raise hand feature. All right, seeing no questions, that concludes the hearing and concludes all of our bills for today. So here's what we're going to do. Let's reconvene officially at 5:15. However, there may be a delay after that, so please check your email, communicate with your staff. Ms. Pop will be in communication with all of your staffs if the 5:15 time changes. All right, with that, we are in recess. Thank you.